You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Welcome to this episode of Let's Get Surety. Today, I have with me my co-host, Mark McCallum, CEO of NASBP. Thanks for being on with me, Mark.
Sure. Hi, Kat. It's great to be back.
And we're talking about your favorite topic today, indemnity.
Indeed.
So to do that, we have on with us today Joseph Young. He's a partner and board-certified construction attorney with Smith Currie in the firm's Fort Lauderdale, Florida office. Thanks for being on with us, Joseph.
Yeah, thanks for having me. I appreciate it.
Well, before we dive into indemnity, can you tell us a little bit about yourself and about Smith Currie?
Sure, of course. So, as you mentioned, I'm a board certified construction lawyer with Smith Currie in the Fort Lauderdale office. My background is in construction management. I had a Bachelor of Science degree from the University of Cincinnati in construction management. So I was in the construction field before I got into law, and then I went to law school at the University of Miami. And my practice is 100% construction law, and I represent all sides of the industry, whether it's GCs, sureties, construction management companies, trade contractors, suppliers, design professionals, owners. Every aspect of construction is what we do, and we do that nationwide. Our firm is, I think, the oldest construction law firm in the country. We practice throughout the country. I believe we've got 9 offices, and I'm here in the Fort Lauderdale office. So construction is what we do, what we like, and what we do well. So that's a little bit about my background.
Well, everyone involved in the surety industry has encountered indemnity at some point or on a regular basis, so they know what it is. But some of our listeners may not. Joseph, you want to tell us what indemnity is?
Sure. So let's talk sort of big picture first of all. So general risk management, the way that contractors manage risk, they manage risk through construction best practices and pricing risks. Those are business sort of considerations. Another way to manage risk is shifting risk downstream to other parties, shifting risk away from yourself to other parties. And then a third major way of managing risk is by insuring it. So if you can't improve your business practices to manage the risk, then you shift it to someone else, or you insure it, or you pay a premium. So indemnity falls under the latter of the two categories that I mentioned, where you're taking your risk and you're shifting it on to someone else. And that's big picture what indemnity is. And indemnity a lot of times gets real confusing and real sort of legalese and technical. But really what it is it's shifting your risk and asking someone else to pay for it.
And you're speaking about contractual indemnity, right? So this is language that is encountered in the construction contract or the subcontract. Is that right?
Yeah, so there's a few different ways where you can find indemnity. Because, for example, insurance is a form of indemnity where you go and buy an insurance policy. You pay an insurance company an insurance premium, and you're shifting your risk of, say, property damage to the insurance company. So that is a form of indemnity that people don't really think about, but certainly there's other ways. Construction contracts. You see them in every construction contract. An owner says, okay, I hire a general contractor. General contractor is responsible for the construction. If there's a claim against me as the owner, I'm going to pass it down to the general contractor through my contractual indemnity. There's also a third sort of concept of indemnity, and that's a concept called common law indemnity, and that's just created by the courts. And basically, it's a concept of fairness and equity that, okay, I'm vicariously responsible. I'm responsible for the acts of someone else. So it's only fair for me to be able to shift my loss to the party that's ultimately actively at fault. And a good example is a general contractor or subcontractor, where a general contractor might be responsible to the owner for the entire project. But if it's a plumbing problem, it's only fair that, okay, the general contractor didn't do any plumbing work. If the general contractor is responsible for a plumbing problem, it's only fair to shift the risk and shift the indemnity obligation down to that plumbing subcontractor who is the responsible trade. So again, indemnity is just shifting risk, and it comes in various forms, but it's all about moving risk from one party to the other.
So, Joseph, so you talk about shifting risk. So, what are some of the common risks that are the subjects of indemnities in the construction contract?
So it's pretty much anything. So any risk that you take, there can be people take risk of defective workmanship. So a general contractor has risk that its subcontractors perform bad work. General contractors take risks of project delays, where if they don't deliver the project on time, and the owner, say, has a liquidated damages clause, where the general contractor is responsible for paying X amount of dollars for every day of delay, and that delay is caused by, say, the structural subcontractor, or the concrete subcontractor, or the electrician, or whoever is responsible. The general contractor then wants to shift that down to a subcontractor. There's also indemnity obligations for non-payment. For example, if you're a general contractor and you've got a subcontractor that doesn't pay its material suppliers, the material suppliers then they assert a lien against the job, or they sue the general contractor's payment bond surety. Well, there's an indemnity obligation that you shift downstream, where a general contractor would say, hey, look, subcontractor, you have to indemnify me and my surety company for these non-payment claims because it was your material supplier that you didn't pay. So those are sort of the three big things where you see, okay, I may be responsible, but I'm going to shift that downstream through an indemnity obligation. So I'd say construction defects, delays, and non-payment issues are one of the major areas of exposure and indemnity obligations.
I imagine, if I'm a project owner, and I'm kind of relinquishing control of the site where the work's going to be done. I don't necessarily want to be responsible for injuries that may result when I'm not, overseeing that work. I have a contract. I've pushed that over to the general contractor. Is that something that is typically dealt with in an indemnity? Also, like, what happens if I'm the owner and there's an adjacent property and, contractor has control of the site again? What happens if there's damage in that regard? Are those things that are commonly dealt with?
Yeah, absolutely. So an owner is what I would call a passive party. So a property owner has some liability to third parties for just the fact that they own the property, and certainly if someone is asserting a claim against them, if someone gets hurt, or if someone's walking down the street and they're on the sidewalk and something falls on them. Well, the first area where that injured person is going to look is who owns the property, because they're ultimately responsible. And that's exactly the type of concept that indemnity covers, where the owner says, look, I'm the owner, but I've relinquished all control of the site to you as the general contractor. You, the general contractor, are responsible for the safety of people around you. You're supposed to put up proper safeguards to protect the general public, to protect the adjacent property, and you're supposed to be you're the one in charge, in control. And that goes back to what I said earlier, is shifting risk from a passive party to an active, what we call an active tortfeasor, and it's really all about who has control of the situation, where the general contractor has more control over the safety of the job site than the project. The same way that a trade subcontractor has more control over the quality of their particular scope of work. And that's why they would be expected to indemnify the general contractor, who would be more of a passive participant in, say, the roofing work, right? So it's the same concept with injuries. It's the same concept with property damage. The one thing about another component of the injury aspect or property damage that isn't necessarily as clear in delays or defective workmanship is there's insurance coverage available. So when you have an injury or property damage, that's typically what you would require your general contractor to have general liability insurance for. And same thing, an owner will typically want a general contractor to add them as what we call an additional insured under the policy. And what that means is, okay, if someone gets hurt, if a third party gets hurt, they then sue the property owner. If I'm standing in the shoes of the owner, I want to go to the general contractor's general liability insurance policy and say, hey, look, defend me, step in and protect me. And that's all indemnity. It's all the concept of shifting risk. Where okay, the general contractor owes the indemnity obligation to the owner, but then the general contractor is further shifting that risk to an insurance company, and that's I mean, general liability insurance is required on every project. So you see that a lot, but I mean, most times if you see an injury or clear property damage, that's going to be a liability insurance issue where the owner and the general contractor are going to be looking to the general contractor's general liability insurance policy to defend and indemnify them for that loss.
Right. So you talked about contractual indemnity. So the provisions, the words. So are these provisions all the same? Are they all vanilla? Are there different types of indemnity provisions?
So they're all actually very different. And what people often do is they gloss over indemnity provisions because they're long and confusing and people don't understand. Right? So I would characterize contractual indemnity clauses into sort of three different buckets. You've got what we call a limited form, and then you've got an intermediate form and a broad form. And basically, just big picture, high level, what the differences are is on a limited form, you're agreeing to indemnify another party only to the extent of your negligence or your fault, right? So if a general contractor is responsible to the owner for construction defects, and I'm a roofing subcontractor, and I'm only responsible for, say, 20% of the total damages, I only have to reimburse the general contractor for 20% of the claim. Which that seems fair. That's the most fair form of indemnity. It's like, look, if I'm at fault, I'm gonna take my proportion of fault and protect you from it. But all your other stuff, all your other trades, general contractor, you have to go deal with it. Okay. When you get into intermediate and broad forms, it's a lot different because broad form, and then I'll go to intermediate form in a second. But broad form, the indemnifying party, say the downstream subcontractor, they're being expected to defend and indemnify the general contractor for all of the general contractor's damages, regardless of whether this subcontractor had a 1% or anything. It doesn't require any type of fault, and that particular subcontractor has to indemnify the general contractor for all of the general contractor's damages, even if the general contractor is entirely at fault. Okay, and then you've got the intermediate form, where sticking with the general contractor and subcontractor concept, where it is, as long as that subcontractor is at least 1% at fault, that subcontractor has to indemnify the general contractor for all of the damages. And when you get into those intermediate forms and broad forms, they're very dangerous for subcontractors, and people don't really give much thought to it. That they're essentially indemnifying or agreeing to reimburse the general contractor for all of the other trades that they weren't even responsible for. So, I mean, some states have tried to create legislation to sort of protect some of the downstream parties from that. What legislatures see as a little bit of abusive indemnity practices. And I want to say there's like 40 some states that have 46 states, according to my last count, that have some form of limitations on what you can do with regard to limited and broad form indemnity. And I mean, 28 states just straight out prohibit that type of indemnity, but it does matter what the language says, because it's a huge difference in the risk profile of what people are taking on.
So, Joseph, are there even situations where one party wants to transfer all of their risk to the other party, regardless of whether or not they are responsible in the least?
That's exactly right. A broad form of indemnity does not require a finding of fault. It doesn't require a finding of negligence, because the idea is, look, anything that you did relates to this claim. So if I'm a general contractor and I get sued for all sorts of different things that all relate to the different trades, and you can't sort it out without sort of figuring it out, the idea of a broad form indemnity is, look, it's once you step foot in this job, you're going to be responsible for everything. And I think it's a very dangerous risk, and that's why you've seen a lot of legislatures sort of step in and say, look, this is too much, because quite frankly, a lot of it comes down to negotiating leverage, and you've got a lot of subcontractors that are just signing on to 200-page agreements that have a bunch of abusive contract clauses in there, that may or may not be fair.
That's a great point about relative leverage, bargaining power. Is there a trend at the state level? You were talking about legislatures. Is there a trend now about excluding indemnity for sole negligence, or are you seeing movement in that regard? Is there more what I call political activity by subcontractors or others?
So, and I do some work with some trade associations on legislative efforts, and it's always interesting, because that's, to answer your question, it's all driven by sort of the politics of the state. Um, I'm in Florida, for example, which is more of a free enterprise state than other states. So Florida is less inclined to enact these type of just uh, say interference with people's rights to bargain and enter into a contract, right? Where, as opposed to other states like California, may be a lot more inclined to have consumer protection statutes and things like that, and have these contractual limitations. Like, for example, I believe that California is one of the states that specifically prohibits these type of clauses. So to answer your question in short, I think a lot of it's just driven by the politics of the state and what's going on. And then within the construction industry, you always have sort of competing interests, even within trade organizations, where you've got subcontractors that want one thing. They want some payment protections. They want protections on indemnity. They want various things. And then you've got general contractors that push back on it. You always have some sort of infighting among the trade organizations in terms of what people want, but it really comes down to the politics of the state and how much sort of protection they're willing to do to get involved in people's contract rights.
It seems like it would be really important to know a knowledgeable construction attorney to find out if whether a particular indemnity is even enforceable, right, in a particular state.
Right.
If you're being pressured, at least you should know whether or not they can even enforce the language that they're trying to push on you, right?
Yeah, that's exactly right. And on top of that, it depends if you have an unenforceable indemnity provision, you need to look at, okay, maybe if I'm downstream and I don't have any negotiating leverage, I'm fine with that, because maybe a court throws out all of the indemnity obligation, as opposed to some other court that may say, no, look, we're gonna enforce it to the extent that we can, which we're at least going to hold you responsible for your fault. So some courts will rewrite these to enforce basically the full extent of the law, and some courts will throw them out altogether. So yes, it does take some sort of studying, some thought, and state specific research to really understand what it is. But certainly, people just get overwhelmed by indemnity clauses. They don't know how to negotiate them. They don't understand what it is. And what I try to do is sort of break it down into parts about, okay, who are you being asked to indemnify? What are you being, what kind of damages are being covered by this clause? And is there any type of limitation? And once you sort of break down the clause and do it a few times, you can sort of get the hang of it. But most contractors just throw their hands up. They might negotiate every other clause in the subcontract and then say, you're going to have to talk to my lawyer because I don't understand this indemnity.
Right.
Yeah.
Yeah. I mean, that raises two questions. One, I think you kind of touched on earlier, which is, so you have the indemnity obligation, but then the parties can also couple an agreement to insure that obligation. Does anybody ever try to get around the enforceability of an indemnity through an agreement to insure?
Yes. So that's actually it's an interesting question because when you've got the states that prohibit what we call broad form, and when an insurance company has an obligation to defend, that insurance company has an obligation to defend all of the claims, not just the claims that it has an obligation to pay for. It has to defend everything. And there are some states where they've tried to shoot down that defense obligation, saying, "Look, I'm being asked to defend against all of these claims, only a portion of which apply to me." That violates these anti-indemnity statutes, and that has that's sort of I'd say a newer trend. I forget what states I saw it in. Maybe I don't want to guess offhand, but I did see that come up recently, and it's an interesting concept because insurance companies are being asked to defend these claims all the time when they only have a portion of the indemnity obligation. So it's really no different in the insurance context than it is in the construction contract context.
Right, right. So what the other question is, when I've seen indemnity provisions, there's usually this litany of parties that are related to, one of the parties asking for the indemnity. Do you spend a lot of time trying to narrow down that litany, kith, kin, consultants, people that walked by the place, whatever it is? How do
Yeah,
you deal with that?
yeah. Look, I never let a client agree to indemnify the owner and his cousin and his mother. No, so in all seriousness, I mean, yes, that's one of the first things that we look at is who are you agreeing to indemnify, and one of the big things that we see, like in I believe in the AIA documents, because they're somewhat protective of architects, but in the owner agreement, the owner is asking the general contractor to indemnify the owner and all of its agents and the
Right.
architect. And what I always say from the general contractor's perspective is, well, why am I agreeing to indemnify the architect? They've got their own design obligations. They've got professional obligations that I don't have any control of. I'm just building what's in the plans that the architect gave me. I'm not going to agree to indemnify this design professional. I'm not going to indemnify the owner for some deficiencies in the architect's design. I'm not going to indemnify the owner for structural engineering issues or mechanical engineering issues. So yes, I mean, I think that it's generally fair to ask for indemnity for, okay, so say an owner and their officers or something like that, if they get sued. But certainly when you start adding in all these other parties who you have no control over and really no responsibility for, we always try to push back on that type of ask.
Yeah, I mean, it sounds like another reason why people should read these provisions very closely, and not just take it for granted that it's in there and that
Right.
they have no control over that.
Right, because a lot of times what happens is you have these indemnity clauses. People don't think about the ongoing risk because when you've got, like in Florida, what's really big is condominium litigation. Well,
Yep.
the litigation arises 6, 7, 10 years after the project's over, and these condo associations do a shotgun approach where they sue everyone on the job. They say that they don't really know the specifics about what caused any type of particular defect, but they've got consultants running all throughout the project trying to identify every defect. So they sue everyone. And if you're the general contractor, I mean, the condo association sues the architect, they sue the engineer, and then you've got the developer coming after you, you've got the architect coming after you, you've got the engineer coming after you, and you've got the condominium association coming after you. You really put yourself in a bad position by agreeing to protect the engineer, by agreeing to protect the architect, because you've already got your own issues, and obviously you're trying to shift that downstream. But maybe you didn't require your subcontractors to indemnify the architect or the engineer. So, I mean, that's something that comes up all the time, where you have to think down the road about what if someone gets hurt, they may not know if it's a construction problem or a design problem, and if you're agreeing to indemnify the architects or engineers, you're opening yourselves up to another claimant against you.
Well, Joseph, I just want to thank you for being on and shedding some light on indemnity clauses for us today. If someone was to take away one key piece of advice related to indemnity clauses, what would that be? What do you think they should take away from this episode?
I'd say you have to read your contract. Right? Understand what your contract says. Understand who you're indemnifying, and don't just gloss over the provision. I think that you really need to understand what you're doing and agreeing to, because it's probably the most expensive risk that you might have in your construction project or contract.
That's terrific advice. Well, thanks again for being on. Hopefully we'll be able to have you on another episode soon, and we'll talk to you again.
All right. Thanks so much for having me. I appreciate it.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.